One of the most important parts of handling your case is something called notice, and it's also one of the least understood and most confusing things to most people that aren't lawyers, and actually even to some lawyers, I'll say, based on what I've seen over the years. Notice just means the simple concept that you have to let the other side know that there's a lawsuit on file, that you have filed against them about your divorce or your family law case. That's the basics of it. And that seems real simple, like, why don't you just text them or email them or call them and say, hey, I filed the divorce like we talked about. Well, that's not enough. And if that's all you have and you go to court someday, the judge is going to kick your case out and you're going to have to start all over, or maybe he's going to dismiss the case and you have to refile. I mean, it's really, really important. So there are three different ways that you can get proof to the court that the other side has notice. Again, text, emails, that's not going to cut it. One way is where you just force it, where you have them formally served with papers. You've heard the movie You've Been Served, you've heard that phrase. Well, that's what that is referring to. And there's a series of steps. You have to go get an official document from the district clerk. That has to be given to an official process server, a constable or a private process server. And then that person, the constable or whoever it is, has to go and in person serve, which means handing to in person the person you've sued over this case. And then they have to confirm that under oath, and then that proof of service has to be filed. There's a lot of steps. The court is, again, really going to make sure that that occurred. That's the worst choice, in my opinion, especially if you're trying to do it cooperatively or by agreement, because that's offensive, stressful when somebody gets served. It's also expensive. So there are two other options where you don't have to go to that expense or that stress. The first one is where the other side files a waiver of citation, and that's just a sworn document that says, I don't need to be served. I've got a copy of the paper and I've served it, and the other side has to sign that document in front of a notary, and then that document has to be filed with the district clerk in your case. Something that's, I think, is an even better choice than that and is simpler is something called an original answer that the other side files. And again, this is if they're being cooperative with you. That's an unsworn document, so they don't have to see a notary. It says kind of the same thing. I'm here, don't do anything without my approval, but I don't need to be served with the papers. And that's what I recommend to most people, is that third option. And in this course, below it will provide you the documents that do that in your case, in all three options. And I'll also lay out to you, again in more detail, how you do each one of those steps so that you can make sure you do notice correctly. Again, don't go to the next step until you've done notice correctly, because your case is not going anywhere until you've done your notice properly.